With me in the studio now is the Communications Minister, Malcolm Turnbull. Thanks for being here.
Great to be here.
Who negotiated this deal with Labor? Was it you?
Yes, yes.
Not the Attorney General?
Well, I had discussions with it's the Attorney General's bill, so he's responsible for it.
But it's his bill, but you did the negotiating.
Well, I negotiated with Claire and Jason Clare and Mark Dreyfus on Monday.
Was that the critical negotiation? Is that what got the deal?
Well, I mean, essentially we agreed on a warrant mechanism for a warrant requirement before police or ASIO could get access to telephone records and IP address information, so-called metadata, where that was being sought for the purpose of identifying a journalist's confidential source.
Okay, you have secured some protections for professional journalists, in inverted commas, against unwarranted access to their metadata, but not for ordinary citizens. Why is it that citizens don't get the same protection under the law as journalists do?
Well, they don't have it now, Tony. I mean, I think part of the problem with this debate is firstly the use of the wretched term metadata, which confuses everybody. We're basically talking about the telephone records that we used to get on our phone bills. You know, your number called that number at this time for so many minutes, and if it was a mobile phone, you were at the such and such a suburb by reference to a base station. And in the internet world, it's simply your customer IP address that's allocated to you when you go online. That type of data, which is part of the business records of telcos, has been accessed by police and indeed, as Tony Abbott was saying in your intro, by a whole range of agencies, local government, even the RSPCA. And that's been going on without warrants, whether it's journalists or anybody else, for a very, very long time.
Well, granted, but you see, when ordinary citizens realise that journalists are getting a protection for obviously some good reason, they'll be wondering why they are exposed and journalists are not.
Well,
or journalists are less exposed, because we'll get into that in a minute.
No, I understand. And so the question that Andrew Wilkie was raising in the debate in the House today with me was, why are journalists different? And the reason you've got to draw the line somewhere. But the point about journalists is that they are in the business of dealing with sources of information on a confidential basis. Journalists have a vested interest, a duty in fact, to protect their confidential sources. And so the concern is that there's often an uneasy balance. I mean, we don't want people working in secret government agencies breaching national security laws and giving information to journalists. On the other hand, however, we want to have a free and robust press that is doing investigative journalism. So you often get a very delicate balance of competing public interests. And that's why there is a special case with journalists. I mean, what
about lawyers? Because you're already starting to hear lawyers say, well, journalists can just shout louder than us. They've got more power because they have media assets that can actually criticise politicians. Lawyers are saying we need the same protection.
But lawyers are a lawyer myself, they're the most self-pitying profession. They're always complaining that everybody hates them. You know, it's really tiresome. So I think that lawyers are seriously though. Look, let me just make this point about lawyers. Lawyers' communications with their clients are protected by legal professional privilege. But the fact of a telephone, if I call my lawyer, there is nothing privileged about the fact that I've called my lawyer. There's no privilege attaching to that. The advice my lawyer gives me and the information I disclose to him in order that he can give that advice, that is covered by legal professional privilege. Right. Journalists have no such. There's no journalistic professional privilege, so-called.
Okay, let's then talk about the role of these public interest advocates. Is it true that they'll be lawyers, and is it true they'll be appointed by the Prime Minister?
Yes, they will be appointed.
So you're picking them from this self-pitying group in the community.
That's right. We're trying to give them a bit of business. You see, we're committed to small business.
But appointed by the Prime Minister. You
yes, that's right. And there is
how is that independent? Why aren't they appointed by an independent body?
Oh, there are similar positions in the intelligence sort of world where independent but people having an independent oversight role are appointed by the Prime Minister as opposed to the Attorney. The reason it's the Prime Minister is that the Attorney General administers, obviously, the police and ASIO, and so you have it appointed by effectively by the Prime Minister, Department of Prime Minister and Cabinet, and there will be a panel of lawyers that will be available. It'll be done exactly, or very similar to the way the public interest advocate.
Do we know how many of them there will be?
Tony, the answer is we don't, but you would clearly appoint a number in each state and territory, and I think they will get very few calls. I think they will spend a lot of time, hopefully with something else to do rather than waiting for the phone to ring.
Let's talk about when the phone rings and they have to apply some sort of public interest test. When you've got confidentiality and privacy on one hand on the scale, and on the other hand the police desire to find information. How are they going to make that judgment? Is it going to be subjective, or is there some rule? Okay, well let me explain. So let's say the police want to get a warrant to access the telephone records of a journalist because they think that he may have a confidential source who is breaking the law, perhaps disclosing information of national security, of great importance and breaching the Official Secrets Act. So, in other words, they've got a great story on the front page of a newspaper or on the ABC, and someone in the security says, "Well, where did that come from?" We better investigate it, right? So they would then go to a judge. And in the case of the police, or the minister in the case of ASIO, the public interest advocate would be notified. The police would make a submission. They'd say, this is why we want the warrant. And the public interest advocate would make submissions in response, drawing to the attention of the judge the important public interest considerations he or she has got to take into account, which are set out in the Act. So lawyers appointed by the Prime Minister will make a decision on behalf of the journalists, is that right? Or make a case on behalf of the journalists? No, they're speaking on behalf of public interest. They're speaking on behalf of the public interest, but the fact that they're appointed, somebody has got to appoint them, and the mechanism, this is a very standard mechanism to have them appointed by the Prime Minister. But the process they go through happens in complete secrecy, is that right? It does. As the whole warrant process has to. It has to, because otherwise, if the police had to seek warrants, in full display, obviously they'd never be. The information that they were, or the goods, or the assets, or whatever it was that they were seeking to search or seize or whatever would be long gone. Okay, that's understood. So if I had a confidential source and discovered that the AFP had actually requested that there be a warrant, and I revealed that to the source, would I be liable, as it appears, to 2 years jail? Would I have committed a criminal act? It's an offence for... The offence is focused on people that are aware of the warrant, and that is basically the police, the judge, obviously, or the public interest advocate. But what if a journalist, because journalists find out information, as you know, what if a journalist becomes aware of the warrant and warns the source, and he's trying to protect that someone's trying to get a warrant on them, then you're liable to 2 years jail, according to this Act. Yeah, but the offence that is created by making public details of warrants being sought, is in the law as it is. Again, there is nothing new here, because you've got to, you see, if you think about it, if the police are seeking a warrant to find information about you or somebody else, there's a massive public interest in keeping that secret. It would be very damaging to your reputation if it was published. No, I understand what you're saying. And it would also frustrate the work of the police. But the new thing here is this secret process. And if a journalist finds that this secret process is underway and there's a public interest advocate speaking on his behalf or her behalf... Well, it's not speaking, it's speaking on behalf of the public interest. All right, speaking on behalf of the public interest and reveals that, they're liable to a jail term, is that right? If the public, let's say the public interest advocate, walked out of the session with the judge and disclosed to other parties that such and such a warrant was being sought in respect to the records of such and such a journalist in order to
pursue such and such a confidential source, that public interest advocate would have committed a very serious offence.
I'm talking here
would
about
probably get struck off, I would think.
I'm talking about the journalist whose job it is to reveal information. In the mind of the journalist, finds out there's a warrant process on a source, publishes it, then they're liable to 2 years jail.
It would, if anyone who publishes information about one of these warrants in this way, is subject to the offence provision,
and 2 years jail.
Well, that's the maximum penalty, but that's in the law now, Tony.
Okay.
Again, there is nothing, I think there's nothing new about this. But if you think about it, how else do you preserve the confidentiality of the process? There's got to be some sanction. Now, the reality is people play by the rules. They're all professional people. They don't break the law. Right. But it is important. It's important for the journalist. It's important for the confidential source. It's important for the police. It's important for the administration and the integrity of justice that confidentiality be preserved there.
Right.
I mean, journalists can't have it both ways, with great respect. You can't say, we want to preserve the confidentiality of our sources, but, however, we want to breach the confidentiality of the warrant, of the application for a warrant in order to frustrate the administration of justice and the investigation of crime.
All right, I think we've gone over that enough. Now, people have been sending us questions on Twitter for you. Here's one that just came in from just another film nerd. Should metadata retention laws effectively outlaw iPhone apps like Wicker?
Well, they don't. Well, they don't. They don't. There's nothing. They're sort of not relevant to it because if you were using a...
So if you're a smart leaker, if you're a smart coup plotter, if you're a smart journalist, you're going to be using...
If you're a smart journalist, and I said this in the House today, I didn't say if you're a smart journalist, but I said if you're a journalist and you are dealing with confidential sources, you, the journalist, have an obligation to protect your sources. And using encrypted messaging applications and taking care that you don't leave an electronic trail is very important. And
the Communications Minister's Advice 101 on how to be a good leaker and how to be a good journalist.
I used to be a journalist. As I said, the Prime Minister and I were both journalists. We've had this sort of terrible progress and tumbled into politics. But you've got your journalists and news organisations have got a duty as journalists to the public interest and indeed above all to their sources to be careful about how they deal with them.
And there are these new methods. Now, on another subject, you recently sent a series of media reform proposals to the Prime Minister only to find them leaked to the media. Have you sought the metadata of those in the Prime Minister's office who had access to your communications?
No, I haven't. Look, seriously, the views that have been attributed to me in the media about media law reform are so well known. I mean, I am very open about my views on media law reform.
Okay, no. Well, I'm not
interested in pursuing leaks, real or imagined. But I can just say this.
What about leaks real? Because presumably it was an email, so have electronic footprints,
Tony,
electronic
honestly,
fingerprints all over it. You're not interested in finding out who in the Prime Minister's office may have leaked this? I'm honestly not going there, and and by saying I'm not going there, I'm not buying into the proposition that it was leaked from the Prime Minister's office or anywhere else. Was the leak aimed at damaging you?
Look, you are free to speculate as wildly and enchantingly as you like, but I am not going to.
You are free in this free society to give an opinion.
I know, but I'm not going to give it. I'm not going to buy into discussions about leaks in the government.
It certainly brought Rupert Murdoch out against you. He tweeted, "Turnbull's plans to scrap certain rules suit buddies at 9." Is he right about that, Rupert Murdoch? I mean,
well, no. I mean, there's a couple of things. I mean, there were a bunch of media ownership laws which were from all of them basically are pre-internet. In fact, some of them are really even subscription television. So they're 20 odd years ago. They're completely out of date. Everyone agrees they're out of date. There are.
Are you planning to overhaul them? That's
yeah,
the critical thing.
No, we certainly are planning.
How quickly can you do that? And do you have cabinet support for the ideas that you're proposing?
Well, in the unlikely event you let me finish a sentence, I'll tell you. We've had a very lengthy consultation process with the industry, and we've had meetings and forums, we've talked about all this stuff for 18 months. So everybody knows what the options are. The media industry is extremely competitive, and people all have a range of different agendas and different tactical positions.
Rupert Murdoch sort of proves that, really, doesn't he?
But everyone does. I mean, I have been, for my sins, one way or another, involved in the regulation politics of the media for nearly 40 years. I've known Rupert Murdoch for nearly 40 years. And so I've seen this film many times before. Everyone's got their own agendas, and that's fine, and they're entitled to have that. But what we've got to do is look, we are a deregulating government. We want to get rid of regulation and red tape. We want to remove the barriers to people doing business. And if there are regulations and laws whose purpose is past, you know, whose object is past, whose context is gone, then we should look constructively at removing them. Of course, you've then got the challenge of, you know, can you do it politically? Can you get it through the Senate and all of that stuff? Can you get it through
Rupert Murdoch, for example? Well,
look,
he's an important guy, isn't he? I mean,
he is an important guy, and he's we know each other very well. I've got no doubt that we can talk about all these things frankly and fairly and sensibly. Okay, I'm sorry we're out of time. We'll come back and finish some of those points later at another time, I hope. Thank you very much for coming in to talk to us tonight. And congratulations on the new format and time, and I hope it's a big success. Thank you.